Prynhawn da a chroeso. Good afternoon, everyone, and thank you for joining us today for our will writing webinar, which we are hosting in conjunction with HCR Law. I am the Legacy and In Memory Officer here in the DVAR department, and it is my pleasure to welcome you all. There's a few housekeeping rules before we begin the presentation. So this is being recorded, and the link will be on the Cardiff University YouTube channel, and you will be sent all details of this in your email. The Q&A function will be available once the presentation begins, should you wish to ask any questions. We've had loads of questions submitted in advance, so thank you all for that. I know Laura's tried to answer as many of them as possible within her presentation, but I'm hoping we'll have some time at the end of the presentation to answer any additional questions. So it's now my pleasure to introduce Cardiff graduate Laura Ikin. Laura is an associate at HCR Law. She specialises in providing advice in relation to wills, lasting powers of attorneys, trusts, tax and estate planning. Thank you, Laura.
Very much, Sarah. Diolch yn fawr. Thank you very much for joining. Prynhawn da, diolch am ymuno. My name is Laura and I'm an associate solicitor at HCR. And I'm just going to share my screen now to get started and start a little slideshow. Hopefully everyone can see this. So as Sarah said, I work at HCR. We are Cardiff-based law firm, just to give you a bit of background, but we have offices primarily along the kind of M4 and M5 corridor. We're quite a large firm. And we provide advice on a very broad range of matters. So private individuals, business owners, families, private, public and third-party sectors. I specialise in private client matters. So that involves wills, powers of attorney, trust advice, inheritance tax planning, probate, anything and everything involving those kind of matters can land on my desk, and it's the area that I enjoy working in. Today, though, the main focus of this webinar is wills, talking about some myths surrounding them, why everyone should have one, how to go about preparing a will, and then how this fits in with broader inheritance tax planning. So the importance of making a will, it gives you peace of mind. So it's the only way that you can ensure that the correct people benefit from your estate in the most tax efficient way and the most appropriate way. Without a will, the intestacy rules apply. So this can leave you with a legal headache, possibly an unnecessary inheritance tax bill, very likely some unnecessary solicitors' bills, I'm afraid. And also you lose control of where your estate goes, and it might not pass in line with your wishes and intentions. So even if you have a will, it's really important that you review it regularly. So I would say at least every 5 years, or when things happen in your life, there is no harm at all in contacting your solicitor, contacting me if you have a will in place, to say, you know, this is what I've got. Does it do what I want it to do, or does it need updating? So it's, you know, it's not something that you just do and put in the cupboard and forget for 20 years. To cover, if we look at some myths that I hear almost daily as to why someone thinks they perhaps don't need a will. I'm married, so my spouse will automatically inherit, or we're common law partners, so you know we've been together for years and we're common law husband and wife. Or I've also heard I live with my partner, but I'm not ready for such a serious commitment. None of these are true. In the first instance, looking at them in turn, it depends on the value of your estate and the makeup of your family situation. It may well be that your spouse would receive everything, but it's not completely guaranteed, and it's very dependent on the specifics of your situation. Second point, in relation to a common law partner, there's no such thing as a common law partner in the eyes of the law. you're either married or in a civil partnership, and I'll use those interchangeably, or you're not. So there are implications if you then die and you haven't provided for the person that you are considering your partner, and they don't have a legal right to anything initially. Again, if you live with your partner, if you die without making a provision for that cohabitee, you're putting them in a really difficult position. There's a lot of insecurity about, can they carry on living in the property? Can they afford to stay there? And you could be leaving your estate open to them making a claim against your estate, which means they can say, well, I should have been left something. And then it's decided through the courts. So, it's a long, costly process, and something that can be avoided pretty much completely with doing a will. I mentioned intestacy. So the intestacy rules are where the legislation sets out who receives your estate if you die without a will. So just to summarise those briefly, if there is a surviving spouse and no children, then in that case, the surviving spouse does receive everything. If there are children, personal possessions go to the spouse. There is a statutory legacy, which is currently £270,000. Don't know where that figure came from, but that's what the government have set. The first £270,000 of your estate will pass to your spouse. After that, everything's divided in half, and then the balance then is divided between the spouse and children. And £270,000 these days is actually quite easily reached when you look at values of houses going up, and if you're paying towards a mortgage, so you're increasing the equity in a property, it's not as big a sum as perhaps you might think it is, and it's not as difficult to reach as you might assume. And it also means then that your children, even potentially minor children, so under 18s, end up co-owning the property with the surviving spouse, which can obviously cause just a bit of a headache and a lot of kind of hassle that perhaps is easily avoided. This is a list of where your estate would pass if you don't have a surviving spouse or civil partner. So it would initially find its way to children, and they would be able to inherit everything then at 18. If you don't have children, it works its way up to parents. If they're not alive, it goes to siblings, whole siblings, half siblings, filters its way to grandparents, aunts and uncles. And if it gets to the end of the line and there's no one in the family to take the estate, it ends up with the government, which I assume is probably not in line with anyone's wishes, really. Just one point I wanted to kind of highlight, which is becoming more and more relevant these days, with more and more people cohabiting and living together but not marrying. A cohabiting partner or any other dependent does not have any legal entitlement to your estate. So if you die without providing for that person to, for example, be able to continue living in a property or receive some sort of financial support, they're not entitled to receive anything. They will probably then find themselves in a position where they perhaps co-own the property that you've lived in together, maybe with your parents, or perhaps children from a previous marriage, or siblings. And with the best will in the world, if everyone gets on, it's difficult. And, quite often families don't get on. So it's putting that person in a very difficult position. And as I mentioned before, it does put them in a position of potentially having a claim against your estate under the Inheritance Act, the Provision for Dependents Act, to allow them then perhaps the ability to carry on living in the property or have some sort of financial support from your estate. With that in mind, there are also things to consider in terms of assets that pass outside of the will and outside of the estate. So assets that are owned jointly, so for example, a house that you own as joint tenants or joint bank accounts, they will automatically pass to the other co-owner, and they won't pass in line with your will. Same then for Pensions, death in service benefits, and life insurance policies, generally speaking, they should pass outside of your estate. So they won't pass under the terms of your will. And they also should pass free of inheritance tax, provided you have an expression of wishes in place as to who you want to benefit. So it's a really effective way of perhaps reducing the inheritance tax bill, but also providing perhaps for different people. And I see quite a lot of clients who have perhaps earmarked a life insurance policy or their death in service benefit to go to children, and then their estate passing under their will going to their spouse. And that's quite common, especially in second marriage situations. So it's important to be aware of how the various parts of your estate will work and what passes under your will and what doesn't pass under your will. I mentioned inheritance tax, so I thought I should briefly summarise on that and give a bit more detail. So inheritance tax at current rates is paid at 40%. And everyone has what's known as a nil rate band. So every individual has £325,000 that they can leave tax-free. So that's taxed at 0%. Everything on top of that is then taxed at 40%. The nil rate band can increase a bit if you are able to claim what's known as the residence nil rate band. So that's an additional amount the government introduced a few years ago, which attaches to your property. So it allows you to claim up to £175,000 extra, provided you have a property or have owned a property, your estate is under £2 million at the date of your death, and the key point is that that property is passing to direct descendants. So it can only be claimed if you are leaving that specific share of your property to children, grandchildren. There are a few other beneficiaries, but it's generally the bloodline. But if you do qualify for that, once you add your £325,000 plus the £175,000 residence nil rate band, that gives an individual a total of £500,000. When you are married, you then benefit usually from what's known as a spouse exemption. And that is basically allowing you to pass an unlimited amount to your spouse. So if you died and you had £10 million in your bank account and you left it all to your spouse or for their benefit, there wouldn't be tax to pay at that point. The tax bill would roll over on and to be paid on the death of the second spouse. So in that instance, the nil rate band of the first spouse would say be 500,000, and the second spouse would also have 500,000. So on their death, it would roll over and they would be able to claim £1 million tax-free before inheritance tax is payable. I should probably caveat this to say this is correct as of today. I know the budget is coming up at the end of the month. There's always rumours about how inheritance tax will be tinkered with and if things will change. Who knows? But I can only base it on as things have been and as they are today. So let's kind of watch this space and see maybe what happens at the end of the month. And perhaps I'll be doing this again in another few weeks if things have changed. There are a few more exemptions that can be claimed for inheritance tax. So charity exemption, so anything that you leave to charity or charitable organisation or another organisation such as a church that qualifies for that status is free of tax. If you're leaving assets that qualify for either business property relief or agricultural property relief, again, that is something that qualifies for a reduced rate of inheritance tax and can reduce the amount of tax paid. And then there's also the ability to make lifetime gifts. So there's quite small annual exemptions. You can make small gifts of up to £250 to various recipients and give away £3,000 tax-free, which is set against your allowance every year anyway. And then if you make bigger gifts, that's when the 7-year rule, which I think most people seem to be familiar with, kicks in. So that gift, you have to survive for 7 years from the date of making that gift in order for that value to drop out of your estate. Just to highlight and talk a little bit more about the charitable relief that's available from inheritance tax. So your will can act as a really good way to think about who you want to benefit outside of family and friends, and perhaps some organisations that are close to your heart and important to you. And lots of clients don't tend to think about it unless prompted, and it's something I always discuss with clients because it can be a good way to do some kind of, or mitigate inheritance tax bill. As I said, there's tax advantages to leaving a legacy to a charitable organisation. They are free from inheritance tax, no matter how much you leave. And depending on how much you leave, it can trigger a reduced rate of inheritance tax to be paid. So current rate is 40%, but if you leave a big enough amount, so 10% of the chargeable value of your estate, which is a fairly complicated calculation to work out, but if you qualify for that, it reduces the rate of inheritance tax to 36%, which can be quite a significant saving. And I thought, just to give some illustration to this, some scenarios here where you can see the difference it makes. So Mr. and Mrs. Bale, no guesses where I got the names from. They have an estate of £2 million. They have nil rate bands available to them of £325,000 each, and that T on there is the transferable nil rate band. So that's the one that transfers on the death of the first person and allows the second person to claim it on their death. And they also qualify for the residence nil rate band. So between them, they have £1 million tax-free allowance. So their taxable estate, the amount that is subject to 40% tax is £1 million, which leaves a tax bill of 40%, keeping things quite simple. Mr. and Mrs. Ramsey, again, they have an estate of £2 million. Once you take away their £1 million allowance, they have made a gift to charity. So they have given £140,000 to charity, which then means their taxable estate, rather than it being £1 million, is £860,000, and 40% of that is £344,000 going to the taxman. And if you compare that to Mr. and Mrs. Allen, again, they have a £2 million estate, very conveniently. Their total nil rate bands are £1 million, so that's deducted. So again, there is £1 million potentially subject to tax. They make a gift of £150,000 to charity. So that's only £10,000 more than the previous family, which means their taxable estate is £850,000. But that extra £10,000 has allowed them to trigger that, that amount that allows them to claim a lower rate of tax. So their inheritance tax bill is taxed at 36%, which leaves them with a tax bill of £306,000 going to the government. So just to illustrate that, you can see it a bit more clearly in the table, how the tax bill, you basically between Mr. and Mrs. Bale and Mr. and Mrs. Allen, there's £100,000 difference there in what's going to the government. But when you look at what's actually going to the family, fair enough, Mr. and Mrs. Ramsey are leaving a bit less to family, but they are benefiting a charity that they want to benefit. Mr. and Mrs. Allen, there's not actually that much less going to the family. What's that? Maybe £56,000. A bit more going to charity and significantly less going to the government in a tax bill. So that's why it's really important. And if you look at the total amount that's going to the beneficiaries, there's quite a significant amount there going to the beneficiaries rather than ending up in the hands of the government. So that's just a very handy illustration to show the benefit of perhaps taking advice and looking through the options and doing some figures to see how adding perhaps a gift to charity or a little bit more of a gift to charity can actually have quite a significant impact on the overall tax position of the estate. So moving on, then looking at actually doing a will, what is, I suppose, what's stopping you? And these are very common comments that I hear from clients. So my circumstances are complicated. It's difficult to decide what I want to happen. A really common sticking point is for families deciding who to appoint as guardians, or it's just something that keeps getting pushed to the bottom of the list. And again, these are common dilemmas that I hear a lot, or, you know, is I want to do a will, but what if, you know, I'm leaving money to my son and then he divorces from his wife? I'm concerned about my spouse remarrying and then how disinheriting the children, or dealing with a family business and perhaps benefiting one person who works in the family business over and above another person. Also how to provide for someone with a disability, and also controlling an inheritance, you know, leaving quite a large sum of money in children's hands is quite a concern for a lot of clients these days. And it's something that does pose a dilemma to them when they are looking at preparing a will. Also, I think the thought of actually doing it and thinking it's going to be long or drawn out or upsetting or complicated is enough to kind of put people off. But hopefully this is where I come in. Generally speaking, it's not a particularly long and drawn out or complicated process. And all of these dilemmas and things that are kind of stopping people doing it are more reasons to actually do one, because if these are your concerns, they can be very easily addressed in a will or talked about, and hopefully would give a bit of peace of mind and would put your mind at rest. And generally speaking, I'd say most of my clients, once we get started, say, well, actually, that wasn't too bad and wasn't as bad as I thought. So just in terms of the will planning process, basically we'll have an initial chat, and it can be in person, over a video call, where we will talk about the value of your estate, how that's made up, your family circumstances, objectives, concerns. This is my skeleton in the closet picture, which is probably not the most appropriate one to use, but it's to illustrate that I need to know everything, and that allows me to advise properly. Because if there are some surprises, and quite often happens that there perhaps maybe children from a previous relationship that maybe a new spouse doesn't know about, or is an estranged child, I still need to know about them, because they can have an impact on the advice that I would give. We talk then about the range of options in terms of structuring the will to best suit your needs. And it's all about being able to make an informed choice and knowing, I suppose, the pros and cons of each option and how you are proceeding. So looking at types of wills, the starting point is usually looking at a straightforward will, which I would consider kind of leaving everything to your partner, your spouse, or to your children outright, and keeping it relatively straightforward. And the benefit of this is that you are able to claim transferable nil rate bands and potentially the residence nil rate band, and it's pretty simple and straightforward to prepare and to kind of put into action. However, I always talk to my clients about the negatives or the pitfalls of perhaps keeping your will in such a straightforward format. It leaves the entire estate vulnerable to the circumstances of the survivor. So if the survivor of you needed care or were to remarry, they have everything in their name that can be taken into account, and can then result in all of that being used or lost or redirected to someone else. And perhaps your children or other intended beneficiaries don't receive anything. There also can be inheritance tax consequences if you're unmarried and you're keeping your wills in a straightforward way. It can result in children inheriting potentially quite large sums at an inappropriate age or time when you are losing control. And also, depending on the value of the estate, it can kind of create generational inheritance tax bills, which can be mitigated by doing a bit of planning at this point in time. So the way and the answer to a lot of those points and things to be aware of are to include a trust in your will. So a trust is essentially a way of making a gift with strings attached. It allows you flexibility and control as to how you provide for beneficiaries. And the assets held in the trust are not necessarily vulnerable to the circumstances and the choices of the beneficiaries. So it takes the asset in trust outside of the estate of that intended beneficiary, but still allowing them to benefit from it. There's various different types of trusts. Main ones that I talk to clients about day in, day out are life interest trust, discretionary trust, trust for disabled beneficiaries, and nil rate band discretionary trusts. And I think it's important to say when someone mentions a trust, I think it creates this image of you only can do a trust if you have lots of money or if you have a very complicated estate. And that's not true. I think I would say at least 50% of the clients I see tend to opt for a trust in their wills, and they are, for all intents and purposes, normal, you know, the house and some cash, but not mega millionaires, not all of them, anyway. So I mentioned life interest trusts. These are really useful in two situations. So the way they work is, for example, if you're a husband and wife, one of you dies, and rather than leaving everything, say the husband dies first, rather than him leaving everything to his wife, and in that scenario, if she then needed care or to meet someone else, the entire value of the estate would be in her name. With a trust, a life interest trust in the will, his will would say, well, on my death, my half of the house or my half or of any bank accounts or savings that I have go into this life interest trust. And the terms of the trust allow my wife to carry on living in the property for the rest of her days and benefit from it. And if there's any income generated, she can have the income generated from the capital or perhaps rental properties. But the capital value of the property and the cash is protected to pass then to children, grandchildren, or down the family line. So in that circumstance, if the wife then met someone else or were taken advantage of financially or needed care, only the assets in her name could be taken into account because the assets held in trust are protected. Again, this works really well for second marriages because it allows a person to provide for their spouse, allowing them to carry on living in a property and benefit from any income generated, but protecting the capital value to pass to their children after the spouse has passed away. I mentioned a discretionary trust. Again, this is super handy, super useful way to pass wealth on or pass assets on in a very flexible and controlled way. And it's a really good way to give effect to perhaps some more complicated wishes. So I do have clients that come to me with very specific wishes, or if there's various properties or they want to have control of how things are used. A discretionary trust is the way to do that in the will. It's also, I use this to provide for a cohabitee to give effect in the same way as a life interest trust would work for a married couple. A discretionary trust can be used to provide for a cohabitee in the same way, and it's in a much more tax efficient way. We would also use discretionary trusts if you have business assets or agricultural assets that qualify for tax relief, because it's important to try and capture that relief at the earliest opportunity. And you would use a type of discretionary trust to provide for a beneficiary who is perhaps vulnerable or has a disability, so that the money is there for them to be able to be used for their benefit without it falling into their hands. Alongside a will containing a discretionary trust, you would have a letter of wishes. So the trust document sets out the kind of legal framework for the trust, and then the detail goes in the letter of wishes. So it would say, you know, it can be as detailed as you want, but how you envisage money, assets being used to benefit those beneficiaries. The key point is it is not legally binding, and that's what makes it, that is a key point that makes it tax efficient. So the very important point there is picking trustees that you trust to follow your wishes. Finally, whistle-stop tour of wills, but before I leave, this is something I always talk about with all my clients because they are as important as a will, is preparing lasting powers of attorney. There's two different types. There's one that covers property and financial decisions, and the other that covers health and care decisions. And a power of attorney is a document that you prepare to nominate a person or people to be able to manage your affairs if you lose capacity to make those decisions yourself. So they are super important, as important as will, maybe more important because you are still here. It's just you are not able to make those decisions yourself. Without a power of attorney, there is a risk of your assets being frozen, even a joint bank account. So if you have a bank account with a partner, if one of you were to lose capacity, the bank may very well freeze at least a portion of that account because they are being very tightly regulated these days as well. Without a power of attorney, if you need to deal with the belongings, assets on behalf of someone, the only way to be able to make decisions on their behalf is to apply to the Court of Protection to be appointed as a deputy, and that is a court-appointed attorney, but you have to go through the court process, you have to pay court fees, and then there's ongoing annual fees as well that are paid to the court. So it's a really costly, expensive, time-consuming, stressful way to go about it. So doing a power of attorney is the best way to have peace of mind that you have nominated someone to look after your affairs if you're not able to. And I should point out, you don't need a solicitor to do powers of attorney. You can do them yourself. Obviously, you get the kind of legal expertise and advice and help with doing the forms, and that's what I'm here for and my colleagues are here for. But it is something that I always flag up to clients, that it is something that you can go online and look at the forms and do yourselves, because the most important thing is you have them. There we go. In conclusion, I hope you found this helpful. So main points to take away is don't put it off. Make a will or review an existing one. If you did a will a few years ago, then it is really important to review it and make sure it does what you want it to do. I have had plenty of clients come to me with wills that have been either drafted by, you know, home kits or someone who perhaps isn't a solicitor doing them, and they're not correct. So it is so important to just make sure, if you've done one, to make sure it still works for you and it is valid. And again, that feeds into the point of seek specialist advice, because it can be worth it. Just to kind of make sure it's structured in the appropriate way, making sure any tax reliefs and tax allowances are able to be claimed. And while you're at it, do a power of attorney as well. There we go. There's a whistle, ending the whistle-stop tour of wills and powers of attorney.
Thank you so much, Laura. That was amazing. I think we've done these about 5 times now, and I'm still there going, oh my gosh, there's so much to take in. So that was a full whistle stop, but thank you so much.
Sorry, I'm having a drink.
As I said, we've had loads of questions, so apologies if we don't get round time-wise to answer yours. HCR Law have really kindly offered all registered attendees a free sort of 30-minute phone consultation. So it'll be, all of that will be in the post-event email along with your link to the webinar again, so you can review everything Laura talked about, but to take advantage of that offer. So I'm going to go through some of the questions now. So quite a lot have come in, as I've said. On the basis of going back to executors, I've got one. Can an executor be a non-UK citizen, so somebody who's living abroad?
They can. It's not completely ideal because depending on what is in the estate and if a trust arises, you wouldn't want just one executor who is living abroad, because that can then create some offshore tax consequences. But it's very common, people have got relatives and children and family members living all over the world. So you definitely can have one, but it would just come down to, again, having a bit of advice, making sure that you're not falling foul or creating perhaps an unnecessary headache down the line by just having that one person living abroad if tax trusts do arise in the will.
Okay, perfect. What happened if a solicitor's firm who helped me draft my will closed? Where would my descendants know how to find the will? What would the advice be there?
So when a firm closes, it's usually either taken over by another firm, or a firm would buy out another firm's will bank. It's always traced through the Solicitors Regulation Authority or the Law Society. So whenever we as firms are really tightly regulated and are monitored, so whenever a firm closes, goes out of business or is taken over, there is always a trail to follow of where that firm's paperwork is held. And it may be that it's transferred to another firm of solicitors, or it could be that it's being taken and being held either by Solicitors Regulation Authority or the Law Society.
Okay, perfect. Will there be a record of that then anyway?
There will always be a record, yes.
Fabulous. So looking at inheritance tax, if someone dies within 7 years of making a gift, who is liable to pay the tax? Would it be the deceased estate or the person who's inheriting the gift?
Well, it's very dependent on the will. And again, that's a conversation to have when someone's making a gift. So I know we're talking about wills and estate planning, but I quite often see clients who are planning to make a gift, and it's something that they take advice on, because it sits within my area and of expertise in terms of inheritance tax planning. It really depends. Most gifts in wills tend to be most gifts are made free of inheritance tax, so that if a person dies within 7 years, the estate would usually cover the cost, but that's not always the case. So it's important maybe to document it. When I meet clients and we're doing wills, I ask them if they've made any gifts and what their plans are in terms of how that inheritance tax should be covered. Are they intending the beneficiary to cover the cost of the tax bill, or is it that they intend the estate to cover the cost of the tax bill? So it's something that, again, is worth taking a bit of advice on, really.
Okay, super. Somebody has messaged to say they've done a £10 will online from a well-known firm several years ago, but would it be legally sound?
Potentially. They're not my favourite, but it's always good that people are, want to do a will. I would be more than happy to look over it and at least give a breakdown of if it's signed. The main concerns with those are not perhaps the content, but if it's been signed properly, dated, witnessed properly. They are quite often sticky points that cause a will to be invalid. So it doesn't, just because it's been done online and was a kind of off the shelf product, doesn't mean it's bad, but it's more a case of making sure that it's been executed correctly. So it's well worth having a review, and I'd be more than happy to do that.
Perfect. My husband and I have additional estates in 2 European countries. Would we need separate wills in all 3 countries, or would a will from a UK cover the EU estates?
The kind of gold standard, the best thing to do is to have a will in every country in which you own an asset, especially if it's property. If it's kind of bank accounts, we consider movable assets, your UK will could cover them. When there's a property involved, it's always best to have a will in that country. That's not to say UK will can cover worldwide assets, but it's very much dependent on which countries they're in, because most European countries have a different legal system to us, and quite a lot of them have what is known as forced heirship, where you don't have freedom to dispose of your estate in any way that you want, which we do with testamentary freedom here, whereas France definitely, and I'm not familiar with all of them, but a lot of the European countries have a system where you have to leave a specific share of your estate to specific people. It could be spouse, children, and then that obviously can create a conflict with your UK will. So the best thing to do is to do a UK will, also potentially do wills in countries in which you own properties, and make sure it all ties together then.
Yeah, make sure it all marries up that way. Okay, cool. Does a marriage outside English law, Islamic nikah, count as a married couple for inheritance purposes in the UK? Do you know, Laura?
That is a very good question that I wouldn't be able to venture an answer off the top of my head. So my initial thoughts are, I don't see why it wouldn't be classed as a valid marriage, and you wouldn't be able to benefit from, you know, inheritance tax benefits in this country. But that would be something that I would need to do a bit more research on.
Perfect. And I've got another one. I'm just conscious of time before we wrap up. Our assets are owned as assets owned as joint tenants pass outside of the will. Does it still form part of the pot for calculation for inheritance tax purposes?
It does. That's a really good question, but yes, it does. So it's still an asset that has to be recorded on inheritance tax forms, but the beneficiary is predetermined to go to the other co-owner, the other joint owner.
Perfect. Okay, thank you so much. So I think that's all we've got time for. As I've said, thank you so much, Laura, and to HCR Law for presenting today. Please take advantage of that 30-minute phone consultation if we didn't get a chance to answer your questions. So at Cardiff University, we've been incredibly lucky to have received some truly fantastic gifts in wills. And as the legacy officer, I'm in the very fortunate position. I'm the lucky one who gets to see firsthand how, you know, the impact that this type of giving can make. It's life-changing. So the legacies that we've already received, some of them have enabled us to do extraordinary things, helping students facing financial hardship, funding life-saving equipment, and several of our researchers, our current researchers, are fully funded by gifts in wills. There's absolutely loads of options, and as a charity, we'd love you to consider us in your final wishes if you are in a position to be able to do so. So if you are thinking of leaving a gift in your will, and Laura's demonstrated why it's such a good choice as well, or just want to explore what options are available to you, please do pop me an email. I'd love to set up a meeting, have a cup of tea, and chat through what we could work out together. So diolch Laura. Thank you everybody for joining us. Have a lovely afternoon and see you again soon.